Hello friends, welcome to UPSC Logics, and in this chapter we shall discuss the basic structure of the Constitution. So this is in continuation with the UPPSC special series, and this is part 8 of the series. And in this particular chapter we shall deal with different cases that have come up since the inception of the Constitution in regards to what is basic structure of the Constitution, what is the definition of Constitution, what all areas of the Constitution form the basic structure. So this hasn't been done in a one-line format and is relevant to all kind of state PCS as well as IAS exams. So let us start this particular chapter without wasting any more time. The question whether fundamental rights can be amended by the Parliament under Article 368 came into consideration in the very first year after the Constitution came into force in 1950. There have been a few cases that have questioned what the Parliament can change and what cannot be changed. The first case in this series was the Shankari Prasad case that occurred in 1951 and was related to the right to property. In this particular case, the Supreme Court ruled that power of the Parliament to amend the Constitution under Article 368 included the power to amend fundamental rights, and the word law under Article 13 meant only ordinary laws and did not include the constitutional amendment bills or the constitutional amendment acts, and hence these constitutional amendment acts were valid. This question, whether the Parliament had the authority to take away the fundamental rights, came into picture once again during the Golak Nath case in 1967. It was in the year 1964 that the 17th Constitutional Amendment Act was implemented and inserted certain state acts into the ninth schedule. This particular Amendment Act was challenged through the Golak Nath case in 1967. Earlier during the Shankari Prasad case, we have seen that the Supreme Court had ruled that the Parliament had full authority under Article 368 to change the fundamental rights or to take them away. It also said that the Constitutional Amendment Acts were not a law under Article 13 and hence were valid if they changed the fundamental rights. The Supreme Court took a complete reversal on this particular stand. It said that the fundamental rights were transcendental and immutable, and hence the Parliament did not have any authority to abridge or take away these particular rights. It also ruled that the Constitutional Amendment Acts were also a law and hence came under Article 13 and therefore cannot take the rights away. The Parliament wasn't very amused with the Supreme Court's verdict in the Golak Nath case in the year 1967. In the year 1971, they came out with the 24th Constitutional Amendment Act that amended Article 13 and Article 368. The process for such an amendment is special majority with ratification by half the state legislatures. This particular Constitutional Amendment Act said that the Parliament had the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the definition of Article 13. The next important case in this particular series was the Keshvananda Bharthi case in the year 1973. During this particular case, the Supreme Court overruled its decision what it had given in the Golak Nath case in the year 1967. It also upheld the validity of the 24th Constitutional Amendment Act. However, at the same time, it laid the doctrine of basic structure of the Constitution. It said that the constituent power of the Parliament did not allow it to amend the basic features of the Constitution or the basic structure under Article 368, and this meant that it could not amend or take away the fundamental rights. The Parliament once again went at loggerheads with the Supreme Court, and to nullify what the Supreme Court had said about the basic structure and not taking away the fundamental rights, it came out and enacted the 42nd Constitutional Amendment Act 1976. This particular Constitutional Amendment Act is also known as the Mini Constitution of India, and it amended Article 368 once again and said that there was no limitation on the constituent power of the Parliament and no amendment could be questioned in any courts or any grounds, and this included the fundamental rights as well. So this was a kind of a draconian measure which the Parliament took to curb the Supreme Court. It was the turn of Supreme Court, and it was seen during the Minerva mill case 1980. The Supreme Court used its power of judicial review, which is a basic feature of the Constitution, to challenge the 42nd Constitutional Amendment Act, and it said that the Constitution had conferred limited power of amendment to the Parliament, and the Parliament could not use this limited power to give itself absolute power. Such limited power is a basic feature of the Constitution and therefore cannot be changed, and does not give the Parliament the authority to destroy the basic features of the Constitution, which meant that the Parliament could not take away the fundamental rights that the Constitution had guaranteed its citizens. The Supreme Court has never specified what are the basic features or the basic structure of the Constitution. However, there are certain elements of the basic structure, and these are supremacy of the Constitution, sovereign, democratic and republican nature of the Indian polity, then secular character of the Constitution, separation of power, federal character of the Constitution, unity and integrity of the nation, welfare state, judicial review, then freedom and dignity of an individual, rule of law, parliamentary system, harmony and balance of fundamental rights and directive principles of state policy, equality, free and fair elections, independence of judiciary, and limited power of the Constitution. So this brings us to the end of this chapter, and I hope you have enjoyed watching this video. Do like and subscribe to this channel, and don't forget to press the bell icon on the subscribe page for further updates and notifications from UPSC Logics. And I hope you have enjoyed this video, and thank you so much for watching, and Jai Hind.